That is the question. On your screen, you guys are going to be able to see the PowerPoint presentation. And I apologize right now, I'm reading off a piece of paper in front of me that gives you exactly what you need to do on this. But on your screen, you will see the PowerPoint presentation in the center of your screen. This should take up most of the screen. There should also be a small box on the bottom right-hand side of the screen with the video feed, i.e. myself. On the left side of the menu, please select the questions and answers icon and type all your questions there, which will be addressed at the end of the webinar. CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report. It will be sent via email within 48 hours following the webinar. These credits are not transferable. Please email education@altitude.law or call Grace directly at 303-991-2076 if you have any questions about receiving your CMA certificates. All right, sorry, now that we are done kind of with that little housekeeping, we can kind of move on to the show. As you guys are aware, pools are a huge issue right now. Major concern for lots of associations as to whether or not the association has the ability to open their pool. If they do, what's the proper process to do that? If a board is choosing not to open their pool, how do we deal with some of the homeowner concerns of the association next to us has their pool open? Why are they opening and we are not? Sometimes they are under a misunderstanding in terms of it's actually a metro district that's opened their pool or something other than an association that's opened their pool, but they might not understand the difference between why one has an easier ability to open versus the other. So we're going to try and tackle some of those issues here. I assume you guys will have some questions, so we will try and get through that as well. But hopefully all of this is going to be beneficial to you. I'm going to try and keep it to about 45 minutes so that there'll be about 15 minutes for questions. Hopefully I don't go much longer than that so we can try and answer as many as possible. But yeah, that's the plan. We're going to go ahead and move forward. So a couple other places you can look at some additional resources. We have been trying to be very proactive, with the COVID issues. On our website, there are a ton of different articles. There's some recorded webinars. There are blogs that are addressing all of these issues that we think are of importance for you. You can also sign up on our website for our blog and newsletter. Those links are below in blue, so feel free to do that. It's very beneficial information. Quick little disclaimer, we're providing information and guidance, not legal advice on this webinar. Also, things move quickly in the COVID-19 world. What we say today may change tomorrow given the continually updated mandates and recommendations. This is especially true for this, as the current Safer at Home order is set to expire today. We don't know what the governor is going to do in terms of, is he going to extend this? Is he going to relax rules? My guess is that he's going to he's going to keep it status quo for a couple more weeks. Had you asked me 2 weeks ago, I probably would have said that we were going to reduce some of the restrictions regarding pools. However, given the states around us and the surge in cases that appear to be happening, I would be somewhat surprised if we relax our guidelines, but we might. You never know. So I would look forward to seeing what the new order is. Another reason for you to come to our website and be on our newsletter and things is to see those updates kind of in real time. We'll blast them out pretty quickly once it comes in. So always be looking to our website for that. All right, let's go to what is next. All right, so things to consider when deciding to open an association pool. First thing that you're going to want to look to are the executive and public health orders. Typically, how this has been played out for the early part of this for the last 3 or 4 months is there will be an executive order issued by Governor Polis. He will then give some kind of guidelines to the public health, CDPHE, the Colorado Department of Health, to create a public health order that goes into a little bit more detail. And then sometime the public health order will then also have guidelines drafted. So all of those things are important to look at. There's also variances that can be given. So just because the state has one set of rules, you also need to look to your local public health orders, because some of the communities like Douglas County just got a Douglas County just got a variance for their pools and some of their other activities. So it's something that you want to look at is your local health orders as well. Next thing you're going to look at is the Colorado Department of Health guidelines. They have given a fair amount of guidelines to help associations and other public entities the ability to open up their pools. Here's what you should do. Here's what we think you should do. There's also the CDC guidelines. Those are a little more robust. Some of them conflict a little bit with the Colorado Department of Health guidelines, but they're both valuable, and we suggest that you probably pay attention more to the Colorado ones in terms of if it's more strict. If the CDC ones are a little less strict, you still probably would want to be abided by the Colorado Health guidelines. Other things that you're going to need to consider are cost, the cost of opening the pool with the guidelines, because there's going to be a lot of additional things you should be doing if you're going to open your pool. You also want to make sure that the association is covered for insurance for COVID-related issues if you're going to try and open up the pool. We're going to talk about all these a little bit more for each slide, but this is kind of a general outline. Liability concerns and whether or not a waiver is beneficial, the business judgment rule, and indemnity. When we're talking about indemnity, we're going to be talking about in terms of board members and whether or not, if the association does not have insurance, if the association would be able to indemnify those individual board members if they are sued in one of these kind of lawsuits. All right, so let's get to the governor's first order. So the order that we're at right now is the Safer at Home and in the Vast Great Outdoors. As you guys are aware, we started off with the stay-at-home order that was in place for roughly 6 weeks. Then we moved into the Safer at Home order, and now we have moved into the Safer at Home and in the Vast Great Outdoors. It's Executive Order D 2020-091. So when you go onto the COVID website, which I assume most of you guys are doing on a somewhat regular basis to stay up on these issues, if you go to the Executive Order section, this is the one that you're looking for, D 2020-091. It is set to expire today. Again, like I said, my guess is that it will get continued for another couple of weeks or maybe a month. My guess is probably 2 weeks, but maybe they'll decide to come out with some new order. This Safer at Home and in the Vast Great Outdoors, we are currently on its 7th iteration. It's been amended 7 different times. The last time was about 2 weeks ago. So under that order, it's going to prohibit gatherings of groups of 10 people unless specifically authorized. It's going to direct the CDPHE to identify, and the CDPHE is the Colorado Department of Health. So when we're talking about the Department of Health, that's what we're talking about. But they're going to identify and develop guidance for personal recreation activities, which include HOA pools. This order is set to expire on June 30th, 2020, unless extended by a further order. Again, I would expect at his news conference today, I don't know when he's having, if it's at 2 or 4 today, but I would expect that we will see some type of new order in place. I'd be very surprised if all executive orders expire today. I can't imagine that we're going to go to a Wild West after today, but I suppose that is a possibility. So again, you want to keep checking on these orders pretty much every day to see what new iteration has come out. So under the executive order, one of the issues with the governor asked for a public health order. So the current public health order is Order 2028. Again, this has been amended 7 times. So I apologize. This is the order that's been amended 7 times, not the Safer at Home. Under this order, and this is when we actually get into some of the actual definitions. So it says that outdoor swimming pools may be open at 50% capacity and limited to no more than 50 people. Now, my guess is that if there is an amendment to the Safer at Home, it's going to increase the amount of people that can be at the swimming pools. If you look at Douglas County, they just got a variance on June 26th. They are allowed to have up to 250 people at a pool. They still have to have they can't be open at more than 50%. So it has to be a pretty large pool to be able to have 500 people so that they can get up to that 250 number. But that is what the Douglas County has been able to get. That's their variance. The reason they were able to get that has to do with the current amount of infection rate that they have. And they have a very low rate. And so the state was willing to allow it. So again, you need to look at each of your local health orders and see if there's anything specifically in there that might allow the association to open at a greater capacity. My guess is if there is going to be an amendment to the current health order, I can't imagine that it's going to lessen the restrictions on how often things need to be cleaned or anything along those lines. But it may, if there is going to be one, I would assume that they're going to allow more people at the pool. Again, though, they've been keeping this 50% cap. So it might not affect your pool if it's not a large enough pool. The other thing that is stated in the order 2028, is that frequently touched surfaces, shared objects, and bathrooms should be cleaned and disinfected every hour. So that's an important point. I've seen some associations open up their pools and they are saying we're only going to clean once a day, or they've talked about trying to open their pools and they want to only clean once a day. think if you do anything that is in direct contradiction of what the orders or guidelines are saying you should do, that you're running a pretty large risk of having some liability for the association and possibly for the individual board members. Basically, our advice to you would be, or the information we'd be providing, is that you should be following the guidelines as closely as possible. Any deviation from these guidelines is a very likely chance that a plaintiff's counsel, if they were to sue the association or the individual board members, they are going to say that your inability to follow these guidelines is negligence. And if we're talking about negligence, then we have issues in terms of, do you have a waiver that can, you're not going to have a waiver that's going to properly cover negligence, because you can't waive gross negligence. So there's going to be all sorts of issues that come into it. So again, the association, if you are choosing to open your pool, you're going to want to make sure you're following the guidelines pretty much to the T. I understand that they aren't mandates, but if someone can show up and show that they contracted coronavirus at your pool and you weren't following these steps as closely as you should have been or could have been, I think there is a substantial amount of liability that the association may be taking on. So under the order of 2028, the governor directed that guidelines be specifically set up. So the state has set up these roughly 8 to 10 guidelines. So we're going to go over each of them and kind of talk about the best way to kind of deal with them. So again, limit the pool as it stands right now. We're going to limit the pool to 50% or 50 people. This is excluding staff, so you don't have to count them into that number. So if you have 4 people that are on staff at the time, it doesn't mean that you have to have 46 individuals there. You can still have 50 patrons and then your additional staff members. They also are encouraging a reservation system to space out attendance, also to help with contact tracing and the equity of the use of the pool. So when we're talking about this, any association that's opening up their pool, you should have a electronic reservation system. Ideally, you're going to have someone that is there to check in everybody. So you're going to have probably a new employee who is going to ensure that if you have a reservation, it's you and whoever you said is coming with you. You are the people that are in attendance. The reason we need to know everybody that's going to be there is in terms of the contact tracing. So within these guidelines, it specifically talks about the state wants to be able to know who is there, so that if someone does contract the virus, that we have the ability to then contact all of those that were in a close proximity and let them know and start following them and testing them if need be. And then the final purpose of the reservation system is basically for the use. So that all members of the association, not just the person who happens to get on very first gets to have a pool reservation, then get a pool reservation every day. Most of the associations that I am seeing they allow you to reserve make your reservation for about a week out. They're allowing only 1 reservation per week, depending on how many they have. And then if there are empty spots after that initial day goes out, you're allowed to then pick up an additional spot each day, assuming there are empty spots. This way, we're allowing everyone in the association the same use of the pool if in fact we are going to open it up. The next part of the guidelines is talking about taking steps to promote social distancing. So some of these steps might be signs around the pool saying, reminding you to stay 6 feet apart if you're not in the same family. Some of it, if you go to the CDC guidelines, they're talking about you should have perhaps the lane markers up. You should have boxes inside the pool or outside the pool that are encouraging this 6 feet area so that everyone knows what's going on. So again, you should be taking some type of step to promote these social distancing. The next guideline that is being discussed is the strongly encouraged to limit pool activity to lap swim. So one thing to take into when you're trying to make these decisions, one of the things that you need to look at is that these guidelines are really written for lap swim only. They're not necessarily meant for open swim. I mean, the guidelines themselves say that if you're going to do open swim, then you should make efforts to reduce in-pool interactions. So really, these guidelines are based off of a lap swim only. So even at that point, if you are going to open up the pool for open swim, you are probably opening up the association to some additional risk, simply because these guidelines aren't really written for an open swim. So if you are going to open swim, you need to make sure that you are making efforts to reduce the in-pool interactions. So whether that is putting in maybe the swim lane markers to show that you have to stay this far apart from each other, or limiting the amount of people that are in there, maybe putting boxes of tape down below so that everyone knows this is where you're supposed to be. These are things that you would probably want to do to help protect the association if in fact they were sued. So again, it is a large risk to open your pool regardless, and probably not every association has the resources and ability to open their pool. To be honest with you, the vast majority might not have those resources. So again, each association is specific, so you need to talk to your legal counsel about that and have them discuss with you the exact process for your association. These are just kind of general guidelines, but you're going to want to try and comply with each and every one of them. So the guidelines go on to talk about the need to clean all frequently touched surfaces, shared objects such as handrails, chairs, and tables to be cleaned every hour between use. We would typically recommend that you're not going to have any chairs and tables out. If people want to have chairs, they should bring their own chair and take it with them. Again, when you have these cleaning things, you should probably ideally you're going to hire a company to come and do these cleanings every hour. You want to make sure that those cleanings are being documented. So every time Johnny goes and cleans the handrails and the chairs, if you have chairs or tables or any shared object, you want to have a log that shows that he did it. I did that at 11 o'clock. I did that at 12 o'clock. I did it at 1 o'clock. We want to be able to show that the association is complying with all of these guidelines. Ultimately, it's the association's responsibility to abide by these guidelines. It's not the individual members. The association is the entity that is running the pool. So we are the ones who are responsible for compliance with the guidelines. It would be difficult to push that off onto the owners as they don't have that same responsibility. So we can't just say, owner, you sign a waiver, you say you're going to comply with all these things, and therefore the association doesn't have to take any of these additional steps. That just isn't a realistic possibility. So the next thing that also takes place is you need to clean the surfaces and restrooms, as well as the locker room should be cleaned every hour. Again, you want to make sure you're logging this. We want as much of a paper trail if you are going to open your association pool to show that you have been complying with these guidelines. So again, every time the restrooms are cleaned every hour, you want to make sure that Johnny writes down that I cleaned the restrooms at 11:15, 12:15, 1:15. Again, you don't want to have lifeguards be doing this, or especially not the lifeguards that are there to be watching the swimmers. So the lifeguard's duty is to make sure that no one's drowning and people are being safe. Their job is not to enforce the social distancing or to do these cleans. If you have multiple lifeguards and you have enough that you can still have one or two, depending on how many people are in the pool watching the pool, and then a third doing the cleaning, that's fine. But the idea that a person would be supposed to be cleaning and also watching the pool would be problematic. Finally, the last guideline is talking about providing physical cues or guidelines such as visual cues and signs to ensure the staff, patrons, and swimmers stay 6 feet apart in and out of the pool. Again, we would want a bunch of signs. I know some of the metro districts that have opened up, when you walk into the pool, they're taking your temperature. Most of the pools that are open are requiring some type of a waiver to be signed. But we also want signs that are up showing that, hey, if you don't live in the same household, you need to be staying 6 feet apart. That's 6 feet apart both in the pool and out of the pool. Again, if you aren't setting up chairs or tables, this is beneficial to you because then you have spaces that people can go. It's easier to not mingle if everyone is not sitting at these specific tables. So if someone brings their own blanket, someone brings their own chairs, it's a little bit easier to socially distance. So that's one thing we'd like to do. So we do have a quick question here. Sorry, just to jump off base for a second, but can lifeguards enforce social distancing in the pool? So yes, I mean, it shouldn't be their guideline. Ideally, you should have someone who is there. You should have one lifeguard that is there simply watching to make sure that people are being safe, they're not drowning. If you want to have a second lifeguard on there that is simply there to enforce the social distancing, then I think that would make sense. But I would not include that as the lifeguard who's on duty who's watching to make sure no one is drowning, that they're also supposed to be enforcing the social distancing. That's not necessarily their job. Their job is to make sure no one's drowning. So I would not recommend having them do both of that unless you have multiple lifeguards on duty and one's doing one job and one's doing the other job. Next thing that we're going to talk about briefly is the CDC guidelines. So the guidelines can be found at the link that's on your screen right now. They break their guidelines down into 4 general topics. These topics are very broad. They have lots of issues within each of them, so we'll kind of go over them relatively quickly. But we'll go from there. So the first one is promoting behaviors that prevent the spread of COVID-19. So in this kind of under this heading, what we're talking about is hand hygiene. We are talking about cloth face coverings. We want to make sure that people are aware, so we want to educate the staff and patrons and swimmers about when to stay home if they're sick. So if you have symptoms of COVID-19 or tested positive for it, or were exposed to someone with COVID-19 in the last 14 days, then we need you to stay at home and not come to the pool. So we want to have something out there that's kind of explaining this to people and not expecting these people to be reading the CDC guidelines themselves. When we're talking about the cloth face coverings, obviously you don't want that in the pool. You wouldn't want them to wear a cloth face covering in the pool, but when they're outside of the pool, we certainly can expect them to wear those. The next thing that we're talking about under this is adequate supplies. We want to make sure that we have hand sanitizer around. We want to make sure that we're keeping the chemicals of the pool proper. We want to have paper towels, tissues, and ideally no-touch trash cans. We want to limit the amount of surfaces that multiple individuals can touch. It's the same reason why we pull away the chairs or the tables, is that we want to make sure that multi-touch items like that and like a trash can aren't being used. If they are out there, then you would want to make sure you're cleaning that every hour per the guidelines. We also want to have posted signs about how to stop the spread and talking about properly washing your hands, and again, just using the basic things that you've been hearing over and over again for the last 4 months. So social distancing, face masks, make sure you're washing your hands, cough into your arm. So all those things, we would want to have some type of sign up that is giving the patrons an idea of this is why we're doing it. And I do see your questions popping up, and like I said at the beginning, I'm going to answer those at the end. So feel free to put them up there, and we will go from there. Additionally, if you have a PA system at the pool, it's not a bad idea under the CDC guidelines to broadcast regular announcements, probably every hour, talking about, look, let's make sure we're doing our social distancing both in and out of the pool. Let's make sure we're not touching any of this, etc. The next big item under the CDC guidelines is maintaining healthy environments. So this has to deal with the cleaning and disinfection. So we need to make sure that, again, the multi-touch surfaces are being cleaned, again, every hour pursuant to Colorado guidelines. The CDC guidelines are saying it only needs to be done daily or at least daily, if not more often, but the Colorado guidelines say every hour. So again, since we're in Colorado and we have a more specific guideline, if you're going to open your pool, you should be adhering to the Colorado guideline in terms of that. You also want to make sure that you're consulting with if you have lifeguards, you're consulting with your lifeguard company so that everyone is understanding what exactly our terms are, and this is what we're expecting from your lifeguards and how many people are feasibly needed for that. Additionally, if you are going to hire someone outside of the lifeguard company that's going to be in charge of checking everyone in and making sure those are the proper people that are here, as well as if you're going to hire someone to enforce the social distancing, you want to make sure that everyone knows what their guidelines are and that we all have a firm understanding of what they are. You also want to make sure that if you are going to leave out any types of furniture, whether that be trash cans or a table or chairs, that those are being wiped down all the time, every hour, and in between uses. So if someone leaves, then it's an ideal time that you should go clean it. Or if you're going to shut down the pool every hour. So how some metro districts and private clubs have opened up their pools, they'll open it up for an hour, and then they'll have a half hour off. So you can reserve 1 hour block. You can have a half hour off, and during that half hour, everyone's out of there. They will wipe down all of the multi-touch surfaces. They'll wipe down the bathrooms, and then start that process over again, be an hour in, and go out. Some of the metro districts and or private clubs are having larger blocks, and when that's happening, they're basically doing the cleaning still on the hourly basis, but they are waiting for individuals to get up. So like with a private club, it's not that hard because they have tons of workers that are there, and they have the ability to go through and say that we can clean this every hour. So if we need you to get up for a couple minutes for us to wipe it down, we can do that because we have enough of a staff to handle it. We have the financial wherewithal to be able to do it. So that's kind of that's why you see those places being able to open up. In the same vein, you see metro districts being able to open up because they are governmental entities. So they have a little bit of government immunity that will likely help protect them if they are sued. They also have bigger budgets in terms of they have the ability at the end of the year in terms of taxes to be able to probably afford a lawsuit if a lawsuit comes their way. So most of the pools that you are seeing opening up are metro districts and are private clubs. You're not seeing very many associations open their pools. There are certainly some, and some of them have the ability to do it because they simply have enough money to do so, and they're willing to spend the extra, maybe it's 40, 60, 80 grand, whatever it is, to pay for the additional cleaning every hour, to pay for the additional people to be there to ensure social distancing. So there are certainly associations that can do it and can open up, but there are lots of risks that we'll continue to talk about as we go through. Again, when you're talking about these guidelines in terms of maintaining healthy environments, you want to make sure that the pool chemical levels are at the right amount. That's one of the reasons why the restrooms stay open, is that when kids or anyone pees in the pool, it throws off that chemical balance. And what we've been hearing is that that can increase or at least stop the preventativeness of the chlorine in terms of stopping the transmission of the virus. So again, we want to make sure all of our chemicals are up to code and doing what we're supposed to be doing with that. We want to make sure that under the CDC guidelines, there's physical barriers and guides. We want to make sure if there's communal space that we're making sure there's signs talking about being 6 feet apart and discouraging any kind of shared objects. So if you are allowing toys into the pool, then you want to make sure that no one else is using them. I would take away any kind of kickboards or noodles or anything like that that are shared use items, because again, you don't want anyone to be basically changing in and out of these items unless they are living in the same household. So the next thing that we're talking about is maintaining healthy operations. So protections for vulnerable staff. If any of your pool staff are in the vulnerable range, so either they have some type of underlying condition or they're above the age of 60, you're going to want to make sure that they have the ability to not be in contact with the others. More than like that, I think this is really more of an issue. Again, we're talking about CDC guidelines, but I think this is more of an issue in terms of a public pool more than an association pool. But it is one of the things they talk about. Lifeguard and water safety. So we want to make sure that the lifeguards are not expected to monitor anything else in terms of hand washing, face covering, social distancing of others. Again, you want to assign this monitoring responsibility to another staff member. That's not to say that when a lifeguard has clicked over, has shifted off of they're no longer watching the pool, that they can't be doing something else. But it is the person who's supposed to be watching the pool should not be enforcing these other guidelines. Sorry, I clicked off of so we're going over these CDC guidelines right now. We're at maintaining healthy operations. I apologize if I thought I'd already clicked to that CDC guideline page, but apparently I had not. The last one that we're talking about is preparing for when someone gets sick. So in terms of that, you want to have some type of process in place for isolating and transporting anyone who actually has, who appears to have the COVID-19 symptoms. So if one of your staff members has that, you want to make sure that we have something to immediately deal with that issue. We also want to make sure that we can notify health officials and close contacts if need be. Again, cleaning and disinfecting, closing off areas used by a sick person. I know that one of the private clubs in Centennial just the other day, their swim instructor came down with COVID, and so this was something that obviously affected numerous kids who were in close contact with this individual for swim lessons for an entire week. So this person probably came in contact with 80 individuals during the swim team lessons or swim lessons, and this person had COVID. So that is obviously an issue. So you need to have some type of way to let the individuals know that someone has come in contact with someone with COVID. There are obviously some issues in terms of privacy that are problematic. So if we are dealing with that, you want to talk to your attorney before sending anything out and make sure we have permission from the individual who's sick. Otherwise, we have to be much more general in terms of describing that an employee had COVID-19. All right, let's move on from the CDC guidelines. All right, next thing for an association. So after you've considered all of the government orders, so the executive order, after you've considered the health guidelines from Colorado Department of Health as well as the CDC guidelines, so one of the things that you need to consider before deciding to open your pool is the cost. So you need to be weighing the cost of paying for the additional cleaning, the additional monitoring of social distancing, and the possible cost of potential suits. So again, when we're talking about the additional cleaning, everything I've been hearing is roughly, it's probably going to cost, you're gonna have to hire some additional people. More than likely, you're probably talking about $20 an hour. So depending, and we've had people talk about maybe we're gonna shorten the time that we're gonna have the pool open. So maybe we'll only have it open for 5 hours a day, maybe 6 hours a day instead of the usual 8 to 10 hours. But that is certainly a consideration that you have to be looking at. So if you're gonna pay someone to clean every hour, that gets expensive. Additionally, if you're going to have someone who's monitoring the social distancing, as well as monitoring the amount of people who are coming in, so making sure that reservation system is being utilized and we know everyone who is there, that's going to be additional costs. So more than likely, you're probably going to have to hire an additional 2 people in order to properly open the pool. So whether or not you have lifeguards is a different issue, but in addition to lifeguards, you're going to need to have someone who's there basically just to do cleaning, and then another person who's going to be there basically just to monitor the social distancing. Board should also be considering the possible cost of a potential lawsuit. So we're going to go into insurance here in the next slide, I think, or relatively soon. But one of the possible costs of potential lawsuits is that more than likely your association is not covered for a COVID-related lawsuit. So what's going to happen is the association gets sued, association submits that to the insurance company, and the insurance comes back and says, no, there's an exclusion in your policy for either some type of communicable disease or whatever the exclusion is, but the likelihood that you're going to be covered is probably pretty small. So at this stage, now it's the association paying its own insurance costs. The likelihood that if this goes to trial, I mean, this is probably going to be dragged out for years. More than likely, it's going to be multiple parties that are sued. And so even if you aren't found liable, there's going to be a huge cost in defense attorney's fees to the association, probably to the tune of, if I had to guess, if this goes to trial, you're probably looking at 150 to 200 grand in attorney's fees for the association alone. Now, if the individual board members are named as well, you may be multiplying that by a factor of 2 or 3, because again, there's going to be tons of depositions. There's going to be tons of issues that are going on that are going to raise the cost of the defense in this case. Now, if you are able to get out with maybe a motion to dismiss, you might be talking about only 50 or 60 grand of attorney's fees. But there's a huge amount of money that is going to be spent in defense costs. So that's one thing that associations really need to be considering when they're opening up the pool, whether if they're going to do it or not. This isn't like your normal pool season in terms of, look, if we get sued because so-and-so slipped and fell, we have insurance, and et cetera. The likelihood is that you're not going to have insurance. If the association is not going to open the pool, one of the biggest issues that we've been hearing about is homeowners want to know, well, then I'm not going to pay my assessments. I want money back, etc. Depending on if you're a pre-Kiowa community or a post-Kiowa community, the idea of what you have to do with surplus funds is different. You're not going to know if you have surplus funds until the end of the year. So we may have budgeted 30 grand for the pool, where we only spent 10 because most of you probably opened the pool. You might be heating it, but we're not going to spend the other 20 on the maintenance or things like that this year. But maybe we have a huge snowstorm or multiple snowstorms that our snow budget goes through the roof, and now that $20,000 got spent there. We need to do a good job of explaining to our members where exactly the money is going. So maybe we're going to try and allocate this for a capital improvement or something else. We need to make sure that we are explaining to the association that we're not just going to pocket your money. We understand that there was money that was set aside for the pool. The pool wasn't able to be opened this year, not by any fault of our own, just as this is what happened this year. But here's how we're planning on spending your money. We're going to look at what happens at the end of the year. And then if it makes sense that we have such a surplus that we could lower your assessments, maybe we could do that. I doubt that it would happen, but it's always possible. But we want to make sure we're explaining to our members, look, you're not going to lose out on a benefit in terms of, hey, you pay all this money and it just goes into the board members' pockets, which some people think it does. That's not what's happening. We are going to spend this on the association. It just might not be on the pool, or it's not going to be on the pool this year. It just kind of depends. All right, so let's talk about insurance a little bit. So prior to opening the pool, I would suggest that all board of directors have a conversation with their insurance agent, with the association's insurance agent. I think it's best to have this not necessarily face-to-face, but either a Zoom meeting, but I would say that it should be the board and the insurance agent as well as the manager. I think just having the manager have the conversation with the insurance agent and then passing that on to the board is not quite as effective. I would want the board of directors to hear specifically from the insurance agent's mouth whether or not the association has coverage. For the most part, we are seeing very few, if any, insurance agents that are saying that an association has insurance. This is obviously very problematic. If you don't have insurance and you're getting sued, not only are you running the risk of, hey, if we lose in terms of liability, so the association sued, the individual who is suing proves that the association caused this harm or was negligent or whatever action took place, but that the association is responsible for the death of someone, not just someone getting sick, but say someone's death. So now we're dealing with a wrongful death suit. So not only are we dealing with a couple $100,000 and probably attorney's fees, we're also looking at $1 million or more in terms of damages. So there are huge risks that are going to come along with opening your pool at this stage. If the government passes some type of immunity where associations or nonprofits get some type of blanket immunity and they can't be sued for a COVID-related issue, that would be probably the best thing that could happen for the association. But as of right now, there's one insurance agent that I know that is saying that it's likely that you're going to have coverage. Again, each policy is a little different, so you got to look at the exclusions, and that's why you want to talk to your insurance agents to determine whether or not this is the case. If there isn't insurance, you should talk to your insurance agent about, is there any policy or rider that the association could get that would insure against such a COVID-19 claim? I don't know if any of those products exist right now. I've not heard of any. My guess is if we are at next year's summertime and we're still in the same boat that we're in right now and we're still having this conversation of can we open pools, I guess by that time, insurance will have created some type of product that will be able to indemnify the association or be able to protect the association. My guess is the premiums will be very high. I would assume, lots of money, whether it's tens of thousands or hundreds of thousands of dollars to purchase such a policy, I don't know. But I would assume if this drags on for another whole year that there will be some type of product by that time. But as of right now, this is such a new issue for insurance agencies that there are not, as far as I'm aware of, there aren't any products right now that are being offered, but you should always check because I would assume it changes probably on a day-to-day basis. So if you don't have insurance right now, and regarding COVID-19, I would certainly check with your broker and see is it a possibility. If it is a possibility, what's the cost? And then we can discuss, does it make sense to spend this much amount of money to cover it? And that's going to be obviously dependent upon each association and how much money you have. All right, liability concerns. So two separate liability concerns. The first concern in terms of liability is the likelihood that someone will be able to prove COVID was caught at the pool. I mean, in most cases, the likelihood to be able to pinpoint where you actually caught it is probably pretty small. The one caveat to that is, look, if there are 6 people that were at the association's pool and they all got sick, that is probably a pretty good sign that they caught it at the association's pool. And maybe we can show that they were at different places together, but that would be your biggest concern in terms of someone being able to prove that COVID was caught at the pool. If an outbreak like that occurs and someone dies or multiple people die, we are talking about huge amounts of damages that the association might be liable for. And again, that could be removed too in terms of, if you have grandparents who have brought their grandkids to the pool and the kids caught it or the grandparents caught it at the pool, and that's usually it's the older individuals that we're talking about who are dying from this. If that's the issue, that's a huge liability risk for the association. The other liability issue is regardless of whether someone can prove they contracted COVID-19 at the pool, the association is still going to have to pay those legal fees to defend the association and possible individual board members. So again, if you don't have D&O insurance or you don't have general liability insurance because it's not covered for a COVID-19 claim, the individual board members aren't going to have insurance, and more than likely what's going to happen when the lawsuit is filed by plaintiff's attorneys, and there's already been roughly 3,000 COVID-related lawsuits filed across the country. We're only 4 months into this issue. We've already had 3,000 filed. So lawsuits are going to be filed. Plaintiffs' counsel, the likelihood of what they're going to do is they're going to name everyone under the sun, hoping to hit. So if someone was at the grocery store, the laundromat, the pool, and 3 other places over the course of 4 days when they contracted this COVID-19, they're likely going to name everybody in that lawsuit. They're likely, if they're going to name the association, the likelihood is they're going to name individual board members. So there's a ton of exposure in terms of just the attorney's fee side of this. And that's not even saying if you win or lose. The likelihood of you being able to say the association wins, the likelihood that the association is going to recover those attorney's fees is probably pretty small. Depending on how these plaintiffs' attorneys draft their lawsuits, the likelihood is that Kiowa is not going to be brought up. If it is, then I think every association is going to make the argument that, hey, since you have brought up Kiowa, we are entitled to our attorney's fees because we won. I think the most likely outcome is that that's not going to be the case, that not hopefully, but that likely these plaintiffs' attorneys are going to be smart enough to know not to use Kiowa because of that specific reason. And then if they aren't using that, unless they are relying on some other statute that would allow for the association to recover attorney's fees, the association is not going to be able to recover them. So typically, we follow what's called the American rule in terms of attorney's fees, which means both sides pay their own attorney's fees, unless there's either a contractual relationship or a statute that's going to change the fact that the prevailing party is entitled to their attorney's fees. So most judges are not inclined to award attorney's fees to the other side, to the winning side, unless there is a statute or contractual relationship. So the likelihood that the association is going to get it is maybe 50-50 at best, but more than likely, if you're spending these couple $100,000, it's going to be spent due to, you're going to have to do special assessments or things along those lines to get this money so you can pay for it. So it's going to be a huge issue, and there's probably a likelihood that some associations, if they get sued, will run the risk of having to file bankruptcy. It's just unfortunately a fact of where we are right now, that if an association chooses to open up its amenities or the pool and they get sued, that there are additional issues. So one thing we hear all the time is, it's okay, we'll just have a waiver signed and then the association doesn't need to do anything. We'll be good, the owners are taking all the responsibility. While we would certainly recommend that individuals have to sign a waiver before they can use the pool, the waiver is not a golden ticket. It's not going to get you out of all liability. So you can't waive away negligence. I can't say, hey, John, you can use this pool as long as you sign a waiver, and I go and pour chloric acid in there and you jump in and burn your whole body. That doesn't mean you don't get to sue me. The waiver is simply for ideas of what's going to be most useful for, ideally, is hopefully it's going to stop individuals or give them second thought if they get COVID-19, about suing the association. However, if they sue, the likelihood is the waiver is going to have a very limited effect in terms of whether or not the association is going to be found liable. Because again, if the association has not followed the guidelines, that's a pretty good indication for a plaintiff's attorney that the association acted negligently. The association was given a specific guideline of this is what you should do if you're going to open a pool. You need to have 50% or 50 people. You need to ensure social distancing. You need to make sure that the pool or that the multi-touch items are getting washed, cleaned every hour. All of these guidelines that they put out there, if the association is skipping out on them, that's a pretty good way to show that the association is acting negligently. So that is a major concern. If the association is acting negligently, the likelihood that a waiver is going to protect the association is very, very small. So while we certainly would recommend that you make everyone sign it, it's not necessarily going to absolve the association of any type of liability. Again, we go back to the fact that it's the association that needs to ensure the compliance with the guidelines. It's not the individual owners or your members. In that same vein, you probably shouldn't be opening up the pool to guests. It should basically, if you're going to open the pool, it should pretty much just be members. We want to limit the pool of potential litigants if you are going to actually open it up. All right, let's talk quickly a little bit about business judgment rule, something that if you've been to any of our other classes, we kind of beat into you as either board members and or managers. So typically, a director is not liable to the association or members for any action taken or omitted if the director acted in good faith, in the best interest of the association, and prudently. So under most scenarios, if a director, the board, has listened to their attorney and their attorney says you should do this, they listen to that, they listen to the other people that they've contacted. If the action is in the best interest of the association, and again, the board is being done, the action is being taken in an informed manner, then individual board members are not going to be liable. The issue in this case, in this situation, is a little different. So one, in good faith. You may have an issue with acting in good faith in terms of there are certainly publications out there, and lots of them, including the CDC Guidelines, as well as the Colorado Guidelines, that say, look, if you're opening a pool, it should only be for lap swim or for something like therapy. Open swim, I've not seen the CDC or the state of Colorado say that you should be doing that. They say you might be able to, but is that acting in good faith? So I think there's a question there as to whether or not you'd be protected, if you'd be protected under the business judgment rule. Excuse me. The other issue is, so in the best interest of the association. So this isn't talking about the best interest of the membership. This is about the nonprofit corporation, the association, best interest of the association. So if the association does not have insurance, is it in the best interest of the association to open it up to a potential lawsuit of hundreds of thousands of dollars, possibly millions of dollars? So that is a huge issue. Are you acting in the best interest of the association? Obviously, if we are defending the board, we're going to be saying they're doing all these things, but there is I think a very good argument that board members might be found to not be acting in good faith or be acting in the best interest of the association, and therefore not protected by the business judgment rule. And finally, I think most of these boards, the advice that they are getting from attorneys across Colorado and really across the country is that it probably is not in the association's best interest to open your pools. Unless you can do X, Y, and Z, unless you can follow all the guidelines and have the money to do all of these things, you're probably getting guidance from your attorneys that you should not be opening pools. So you're not necessarily acting prudently if you're going against the attorney's advice. So I think you're going to have trouble with the business judgment rule if the association opens its pool and gets sued. I don't know if individual board members are going to be protected or not. Final issue, so if the association does not have D&O insurance, so if board members have chosen to open up the pool, can the association indemnify them? So Section 7 of the Colorado Revised Statutes, this is the nonprofit code. So nonprofit corporations have the ability to indemnify directors if the person's conduct was in good faith, if the person reasonably believed in the case of conduct in an official capacity, which we're talking about, the board, but the conduct was in the best interest of the corporation. So as long as the board member was acting in good faith and was acting in the best interest of the corporation, the association can indemnify the directors for their attorney's fees. So if we could indemnify and the association and the board members are sued, then presumably we'd be able to take money from the association to pay for both the legal costs of the association and the board of directors. Now, in order to do that, we have to show that the person's conduct was in good faith. Again, we talked about it with the business judgment rule, as there's at least an argument that such action was not in good faith. And then it also has to be done in the best interest of the corporation. So again, is it in the best interest of the corporation to allow someone to swim for 8 weeks, have the ability to swim for 8 weeks? Or is it in the best interest of the corporation to limit the association's liability in terms of, hey, we don't want to expose ourselves to possibly $1 million or more in damages and attorney's fees? What is the best interest of the corporation? I think that plaintiff's attorneys will certainly argue that the best interest of the corporation would probably be not to have opened the pool because their client got sick after the pool was open. And there was really no benefit to the corporation in terms of having the pool open. We're in a scenario right now where numerous association pools are not open. You're not losing out on any type of new people moving in because the pool was closed for 1 year. So I think that there is a strong case that the best interest of the corporation is not being had when you are exposing it to huge amounts of liability, which you don't have the money to pay for. Now, that changes if you have a huge reserve policy or something, huge reserves or something along those lines. Everything, again, is fact specific. But that's kind of where we're at in terms of talking about indemnification. All right. I think we got through the slides. Let's go to the top of your questions, kind of go from there. Feel free to add them in right now if you'd like to. So the first question that I have is, can lifeguards, we already did the lifeguards and guard engage in social distancing, sorry. Can we get a recorded session? That was answered. So how to handle when small HOA doesn't have a lifeguard. So if you don't have a lifeguard, you still should be hiring someone to monitor the social distancing, and you still should be hiring someone to be taking care of the cleaning as well as the reservation system. So even if you don't have a lifeguard who's there to be protecting someone from drowning, you should still be compliant with the guidelines, which more than likely is going to require you having someone who cleans every hour, as well as someone who's monitoring the social distancing and the third factor, cleaning, social distancing, and I'm just trying to think right now. But all the things that we've just talked about, I apologize. So can volunteers take shifts to do an hourly cleaning if they are provided training? I would recommend volunteers not be used, mostly because if you are going to open your pool and you contract with someone, so if you're actually paying someone and contracting with a company to do this cleaning, and say they don't do the cleaning, and the associate, so you've contracted with someone to clean every hour, they failed to do the cleaning, and the association is sued because someone caught it and they claim that you weren't doing the cleaning. We can now turn around and sue that company. It's not going to be a COVID-related claim. It's going to be a breach of contract claim. And more than likely, their insurance is going to pick up a breach of contract type of claim in terms of, hey, we did not do what we said we were going to do. And now we have another pool of money that we can pull from if need be, if the association is sued. If you are going to, there's nothing that would prohibit you from using volunteers to do this. However, if you're going to do that, I think you need to explain to the volunteers that they are likely taking on personal liability as well, because they aren't going to have insurance for this if they fail to do the cleaning like they said they were going to. So I think volunteers are problematic. I would not recommend doing it. If you are going to do it, I think they should consult with their own attorney and or insurance to see if they have any type of coverage if they take on this volunteer role and aren't properly doing what they're supposed to do. More than likely, too, if a volunteer is there, they're going to get named in a lawsuit. And so they're going to be taking on the cost of additional defense fees. And they're not a director, so they're not going to get covered under the indemnification clause. So again, it would be problematic in my mind to have volunteers do it. Next question is from Christy. It says that you said this is not okay to tell the homeowners that these are guidelines and they should make sure they take place or police themselves. What are your thoughts on deputizing homeowner volunteers to create notes in the process? So this is another kind of volunteer question. So again, to reiterate the fact, it is not the owners or the members that are responsible for complying with the regulations. These guidelines are out there, and they are the guidelines put out by the state for the operators of the pool in order to open the pool. So it is the association as the operator of the pool's responsibility to make sure these guidelines are followed. It's not the individual members. Again, like we already talked about, what I just talked about in terms of volunteers, I think there are lots of issues with having volunteers do it. I think the better way is to hire someone to take care of it. Next question is, what if the HOA allows short-term rentals? Would you recommend any additional guidelines? In terms of short-term rentals, I would say that unless you are an actual member of the association, I would not recommend allowing those individuals to use the pool. Again, if you have, the more people you have using the pool, and if they are outside the association, the greater the pool, the risk is in terms of there's more people that can sue the association. So I would not recommend allowing short-term renters to use the pool. I think you need to create a rule that during this time, only members of the association are going to be allowed to use the pool. Again, you're going to want to require a waiver from everybody that uses the pool. Keep in mind when you're talking about a waiver, I can't sign for another adult, so I can't sign for my wife. I can sign for minors, but each adult is going to have to sign their own waiver. Next question is, could you please comment on how helpful it is or not to have people sign waivers? So again, if you're going to open the pool, I highly recommend you have people sign waivers. When push comes to shove, the waiver I think will provide you some benefit in a lawsuit, but it's not going to be a blanket immunity. So I think it's beneficial. I think everyone should do it. But in terms of is this going to protect you from liability, the likelihood is probably not. Next question is from Kate. Wouldn't COVID lawsuits be a reason not to open any amenities? Yes, I think that there are, for all of the amenities that are out there, there are different guidelines. And if you are not following all of the guidelines, if you don't have the financial means to do it, then you probably should not be opening up any of the amenities. To open up To open up a clubhouse or something like that without following all the precautions that are required under the guidelines, it wouldn't make sense. You're opening up the association to the same kind of liability. The board members are opened up to the same liability. So I would not recommend opening up any amenity unless you're following all the guidelines that are out there for that specific amenity. Whether that be a gym, whether that be a clubhouse, whatever it is, the pool, obviously this whole class has been about. But yes, this is going to apply to all of the amenities. Next question from Craig. Would it be safe to say that these liabilities could be considered when it comes to community grills, fitness rooms, and other amenities? So basically the same question as Kate, and the answer is the same again. Yes, you need to be complying with all of the guidelines that are out there. So any amenity, any item that is going to be used by more than one individual or is not owned by someone that is owned by the association, run by the association, then you need to have this same conversation. You should be talking to insurance agents. Are we going to be covered? Are we not? Is the board covered, et cetera? And those same considerations that we talked about in terms of liability would apply to them in the same manner. Now, you might be able to say that the tennis courts are used in a much more infrequent manner, so we're willing to take that risk more than we are to the pool that is going to have a high amount of people in it for the entire time that it's open. So that there are different evaluations of the risk that might lead to different decisions from the board, but in terms of the liability, it's still there. Marie asked me basically same question in terms of basketball courts, tennis courts, playgrounds. Again, all of those amenities that are there, there are different guidelines for them set forth in the public health order, and you need to follow all those guidelines. It's the same analysis again in terms of liability and risk. So you need to again contact your insurance agent, contact your attorneys, and before you open any of these amenities, you need to do that so that the board is aware of what exposure they might have and what the association is going to have if they choose to open up any of these amenities. So it looks like Kevin talked about again. Looks like a lot of these questions are about can we open the exercise room or other amenities. Again, looks like this question, we would limit the exercise room to one person at a time or one unit family at a time. So again, in terms of exercise room, I'd have to go, again, this was for pools, but the guidelines I believe right now for exercise rooms say that the equipment has to be cleaned by between each use. So if you are going to have someone come in and clean after each use, again, you can't push that off on the individual owner or member. It's great to say, yes, they should clean it, and they hopefully will clean it as well. But you, as the association, need to come in and clean after each and every use. So again, it's the same risks that have been put there, but it's, again, the same analysis. Tim Bennett, what is liability exposure for a manager in the case of a lawsuit where a manager is named? Does it depend on what coverage the management company provides? So likely, just like the board and just like the association, it is highly possible that the management company and or individual manager are going to be sued. Again, just like with the association, the likelihood is that there's not going to be insurance coverage for the manager or management association. Most of your management agreements probably have some type of indemnity provision in there. So the association may be on the hook from a contractual standpoint, to pay for the management's attorney's fees. But again, if the association doesn't have money, that could be problematic. So I can't really answer your question in terms of liability exposure, but the manager is likely to be named in a lawsuit. In terms of opening indoor pools and spas, what is the difference? So the amount of people is mostly the difference in terms of the indoor versus outdoor. This was geared mostly towards outdoor pools, but there are indoor pools are allowed to be open. The numbers vary a little bit in terms of how many can be in there. But Merle, I can go ahead. I'll get you the actual specifics on the indoor pools and shoot an email to you on that. Besides that, we are at our hour. I really appreciate you guys coming and listening to this. Hopefully it was beneficial to you. Outside of that, if you have any questions, please reach out to us. We've been dealing, just like you have, with these pool-related questions for the last month and a half, 2 months, and so it's a big issue. So again, thank you very much. I will try and email these last couple of questions that come out to get you some answers, and we'll kind of go from there. You guys have a great rest of your day.